Hi people, this is Manisha Rawat from Bat Frigate, and I thought of sharing a simple video with you people so that you can understand how attorneys work and what are the challenges that we as patent attorneys face while dealing with most of the projects, and that is why I thought of sharing this information with you. So to begin with, I would like to draw your attention on the kind of clients that a patent attorney has to deal with. That could be a solo inventor. He or she could be uh, the conceptualizers of a particular invention. You can be approached by a business, you can be approached by startups. Most of the time we work with the startups as well. And similarly with the people who are constantly involved in the innovation business. Now, what is the role of a patent attorney? I would like to explain you that. So as a patent attorney, it is very important for you to understand the requirements of the client. It's very important to understand what is the innovation that the client brings on the table. Is it a novel product or a novel process? Is it not? All these things are given consideration, and they could be spoken about only after validated searches. That is a part and parcel of the protocol of patent searches. So before approaching a patent attorney, what you need to know, I would just give you a perspective on that. Yes. So before approaching a patent attorney, you need to have a clear understanding of your query. You need to have a clear understanding of your product or the service that you tend to protect eventually. For example, you might be having a brand that you want to trademark, so you can approach a patent attorney or trademark attorney for the same. And you might be having a certain out-of-the-box innovation that nobody has achieved and nobody even thought about. So it's a good idea to approach a patent attorney for the same, because he or she will take care of the inventions and drive you through the entire process of attaining patents over your innovations or inventions. Apart from that, there may be chances that you don't want to go for a formal patent, you don't want to go for something like a trademark, registering your brand name. So in that case, for example, you think that you have a product that looks very beautiful. You have a kitchen utensil that might be having, a certain ornamentation or aesthetics that is very unique to it. So what in that case? Who to approach, right? Shall we go ahead and trademark the brand name for that utensil, or do we have other options? So in that case, I would recommend you to go for the following options. You can first go for a utility patent if that particular utensil is intended to solve a utility problem, or intended to serve a certain utility. Then definitely approaching a patent lawyer, a patent attorney for drafting your patent utility application is one choice. The second thing, if the design is very unique, maybe it doesn't offer a unique and novel utility, and the utility has been around for times immemorial, but the design is unique. In that case, you can just go ahead and file a design patent application which will protect the ornamentation and the overall aesthetics of the product. Mind that a design ornamentation or a design patent won't lead to something like a utility patent, which will be granted for a period of 20 years. But yes, you can certainly gain the patent and the IP right over the aesthetics, ornamentation of the product. So even if that is not the case, and you want to go ahead and file protection for the brand name, how would you approach and who to approach? In that case, if you're just intending to protect the brand name, I would just ask you to approach a trademark attorney or a trademark professional who could register the brand name for you. You might be having a number of brand names. It's a good and smart way to approach a trademark attorney and or a paralegal expert in IP law, so that they can just conduct a trademark search for you, let you know that your brand is available or not. If it's available and it's good to go, he will just ask you to file a trademark application at the respective jurisdiction, and there you go. And if at all your brand name is something which is very repetitive, it has elements which are which cannot be trademarked, or it's not unique enough, then your attorney or the person who is giving you consultation would definitely tell you that this is something which could not be trademarked. Think for another alternative name, or likewise. So these are a few options that you can actually exercise before approaching an IP specialist, an IP attorney, trademark or patent attorney, and get sorted. So I hope that these little tips would help you in your IP protection journey. If you feel that there is any question that always bugs you, if you feel that you need to contact us and ask us your IP queries, I would like to read your emails personally, and you can mail me at patfrigate@gmail.com, or you can mail me at my official ID, which is contact@patfrigate.com, and I'll be glad to help you. Thank you.